Well, hello and welcome to today's HIPAA chat. I'm Carol Fly with High Tech Answers. Thanks for joining us after a month or two off. We're going to be talking about HIPAA fines and OCR audits today. How much are you at risk? If you're a first-time attendee to HIPAA chat, we hope you enjoy the experience. This webinar is really not a webinar, but more of a webcast or a web event where we're here to answer your questions. So we're looking forward to having our experts today in today's event. HIPAA Chat is sponsored by eFax Corporate, which is a brand of J2 Cloud Services. For 20 years running, the fiscal year revenue growth, and they've got some great products related to HIPAA compliance. So please check them out at enterprise.efax.com. You can find past events of HIPAA Chat on YouTube and under our radio channel. You can download podcasts of previous shows on our radio station, healthcarenetradio.com program/HIPAA Chat. And you can also listen to HIPAA Chat stream live at 12 noon or 7 p.m. Eastern on our internet radio station, healthcareNowRadio.airtime.pro. We've also created a HIPAA Chat LinkedIn group. So if you go to LinkedIn and you search for groups in HIPAA Chat, you'll find us there. You can post questions and engage with the group on all things HIPAA. We're very excited about our experts this month. We've got a couple of new ones joining the High Tech Answers fold, and they are from the Compliancy Group. And we've got Bob Grant, he's Chief Strategy Officer of Compliancy Group, and Mark Haskelson, the President and CEO. They're here to address your questions through the registration process and also any of those that were asked live. Hi, Bob. Hi, Mark.
Hey, how's it going?
Hey, Carol.
Good. How are things with you guys? Thanks for being our experts on this month's HIPAA Chat.
Our pleasure, and hopefully the attendees find our answers interesting. We'll do our best to make it a little bit more dynamic than what the traditional dry side of compliance is.
Yeah, well, but in all seriousness, I think one of the things that you guys are going to talk about today and answer questions on are HIPAA fines, and a lead into that, of course, is there has been a lot of news and buzz around the 1.5 million fine for a Minnesota hospital for, I think, a lack of a BA agreement or an improper BA agreement and security risk analysis. So that's probably, I think, a good entree into what's going on with these fines and, of course, phase 2 OCR audits that have started up again.
Oh, exactly, Carol. I think that, most of the, and I talk about this all the time when I'm doing presentations, is a lot of these fines could have been avoided if you'd have just followed the 7 rules of OIG and put those in place into your organization or your practice or, your office, whatever you're doing. And if you would have done, if these people would have done a risk analysis and had everything in place that they were supposed to, most of these, even though they happened, they would have been able to show that they were making a good faith effort, but obviously they weren't, and that's why they got fined the large amount.
And was there one today? Is that what you said, Mark? You were talking earlier?
Yeah, there was a $750,000 suit that was settled today with an orthopedic group. And it's the same thing. They were charged for not having their business associate agreements in place. And, it's amazing. One of the trends we're seeing, the historically people would say, well, my chances of getting audited are next to nothing. And, even if you take stage 2, it's going to be 150 companies across the country. But if you look at what you saw, let's say, today with the orthopedic group, you notice the trends. It's no longer the big groups. It's nonprofits, schools, counties, dentists, orthopedics. They're going after the groups that historically, I think, have been the least compliant groups in the United States. So it's time to start getting the basics in place before you get caught.
Yeah, and actually the OCR went on record saying they were widening the net this time for phase 2 to look at business associates and sort of smaller organizations and providers. So, well, with that, looming over the conversation today, I'm going to turn over to you two so you can start addressing the questions from the registrants and from our attendees.
Great. All right. So let's take the first one that was submitted. And by the way, folks, please do continue entering them. You have the ability on the on your GoToWebinar to enter questions to us. So as we, the more the merrier. Obviously, that's the goal of today. So the first one that came in from you folks in the registration process was, when does an organization get fined? Will organizations get fined if they have documented proof or best efforts in compliance?
Oh, that's interesting. It depends on what you think best efforts are. And it depends on what they think best efforts are. And so the government has set forth 7 fundamental elements that they're going to look at. They're going to look at, do you have written policies and procedures? Do you have a designated compliance officer or a privacy and security officer? They're going to ask for your training and how you trained and educated your staff. They're going to ask for, do these people who got educated know who they need to go to in the case of a breach or something that doesn't appear correct? Are you doing this yearly? Are you doing this internal monitoring, and are you doing the monitoring daily, weekly, monthly, and are you auditing yourself yearly? Do you have a sanction policy that if somebody does something wrong, how do you discipline them? And then finally, do you have an incident management system, an incident management program, that goes on to, if an incident happens, how did we investigate it? Did we run a risk analysis, etc.? So depending on what you think are best efforts, they may not think are best efforts, and you may get fined. Now, the level of fines are based off your best efforts. So if you did 70%, you did 60%, they may say you're in the $10,000 level. And so now it's 10,000 times how many things they find wrong. They may say, you know what, you did okay. We're going to give you a corrective action plan, and we're going to fine you $100 per event. They may say, it's kind of like going for a tax audit, right? You go into a tax audit, you better have all your ducks in a row or they're going to fine you. Same thing's going to happen here. Right? They're not going to say, oh, if you thought that was what best efforts were, that's fine. They're not going to do that. Now, HHS, the leader of HHS has said, this is not a witch hunt, right? We're not out there going to fine you, we're going to be hard on you and fine you, so it just depends on how close you are to these 7 elements that the OIG have put out there, is how close they're going to say that you're meeting best efforts. So when will you be fined? It'll be shortly after they do what they'll do. They'll come in, they'll ask for the desk audit. If you're not meeting it, they're going to show up on site. They're going to review everything, and then when they go back, then comes your bill, or not, depending on what they find.
All right. So let's see. Let's take the next one. What IT needs to be in place to be HIPAA compliant? A type of email, how documents are kept, servers, exchanges, etc.
That's a good one. Okay, so I'm sure everyone on here has heard about the risk analysis. If you did meaningful use, or you're trying to be HIPAA compliant, the first thing they're going to look for is your risk analysis when it comes to security. They're going to want to know, did you look at your servers, your firewalls, your routers, your wireless routers? They're going to want to know, did you make sure that, did you do a vulnerability test, right? So the smaller you are, the easier it is for you to lock down one firewall, one router, and make sure that, that people coming in from the outside can't attack you. As the larger you get, you may have to have a vulnerability scan. That is where somebody's on the outside trying to pound through to get inside your organization. That is something you really going to want to do, right? So did you do a vulnerability scan? Is your server set up? Now, let's talk about encryption, right? So here I've got this network, and it's got a server, and it's got data on it, and it's communicating all around my sites. And the rule is you're supposed to encrypt data at rest or in motion. So great, that's great, because that's a really good protection. The problem is, in some areas and in some companies, if you encrypt that server, everything stops talking to everything. So now note that the systems can't talk to each other, and now you're dead in the water. So when you think about what the rule says, right? The rule is basically saying you must protect the data. So if you go in and it says do encryption in data at rest or in motion, and you can't do at rest, then you need to figure out a way to protect it physically, right? Put it in a cage, put it in a locked room, in a cage in a locked room. So that way, have alarm systems on your building. I fight with people over this all the time. If you don't have alarm systems on your office, and somebody breaks in on a Friday of a 4-day weekend and takes your server, and you come back on Tuesday and you walk in and it's gone, and you go, whoa, all the data's gone, and then you call HHS and say, hey, I'm reporting a breach, somebody broke into my office and took my server, and they'll say, well, what happened when the police came, after the alarms went off? Well, the police didn't come because we don't have alarms. And they're going to say, well, do you really think that was protecting the data? And you're going to sit there and they're going to say, you mean you couldn't get a $124 alarm that alerted the police? Here's your fine. Because you really didn't protect the data, did you?
I tell you also, Bob, in addition to what I often see and is that people often mix compliance and security as one thing. Right, and what you have to, think of it from compliance as a function of being HIPAA compliant is, are you doing something, are you not, right? And if you're doing it well, you could still have an incident, right? A laptop can be stolen, a device can go missing, but what happens is if you can show that you have the basics in place, that you've done, as Bob keeps referring to the 7 elements of an effective compliance program, you're not looking at fines. Whereas security, what we see is a lot of people misunderstand. Security is about risk, right? You could spend an unlimited amount of dollars. You could keep spending money to be quote unquote 99.99% risk-free in regards to your security, but it really does depend on your organization. So often when we're talking to clients, if you're a small doctor practice with a couple of PCs, your IT risk is very different than a regional group that might have 5 facilities and a lot of, let's say, bring your own devices. So in your mind's eye, start thinking about, are you doing everything appropriately from a compliance perspective? And then are you also addressing all of what is the security needs? Because it's amazing how many folks will invest heavily on security. And the example Bob was giving of, where they invested in, an incredible amount of money in securing a server room, but then forgot that the server room was also a storage room. And what happens is half the time people prop the door open, and that's where the security risk was, right? Is just making sure your staff understood, or might have been as simple as moving that stuff into another room.
So it's actually, Mark, a combination of both, right? So
absolutely.
You can, if you do one heavy and don't do the other, you could be fined. If you do the other one heavy and don't do any encryption or any security reviews and things like that, you could be fined. And you could be fined to the full extent. So it's like a handshake, right? So that's why when you look at what the government is looking for, they're looking for you to look at your administrative side, which is your policies and procedures covering privacy and security and breach notification. They're looking at you to look at the technical side of your firewalls, your routers, your servers, all your devices, your workstations, your laptops, your iPhones, anything that's connecting to or storing PHI. And they're also looking for your physical site. Do you have alarm systems? I can't tell you how many that I still see today when I go and look at reported breaches of people who throw paper away. Paper is as bad as electronic. And all these people, all of you who have gotten EHR systems where the sales rep said, oh, you're going to love our system because we're going to make you paperless. And now you find out you're printing more paper than a forest. what's happening to that paper? Is it going in the box at somebody's feet? Does it get emptied into a locked shredder box every night? Or does it sit there and get full till it takes 3 people to drag it across the floor to the locked shredder bin? Maybe you don't even have locked shredder bins. Well, that's not good either, right? So you should take care of the paper and the electronics. So that's why they ask you to do administrative, technical, and physical. So if you can show that you've done those 3 audits, and then whatever deficiencies you found wrong with those 3 audits have been cleaned, meaning that I have all policies and procedures now covering privacy, security, and breach notification, covering all aspects of the rule, that I have all my technical audits and all my physical audits, and now I take those policies and train my staff on the basics of HIPAA and the policies that are in place. Now you got a compliance plan. That's what they're looking for. If you have a compliance plan, you're going to be at the lowest level. And if somebody does something even though they understand they weren't supposed to, well, that's why you have the sanction policy. So it all comes down to how much can you provide to them that shows you made a good faith effort based on what they think a good effort is, not what you think a good faith effort is.
All right, so let's keep moving on. So what are some examples of fines? And Bob, let me take a little bit of this. If you look at last year, right, last year was a really interesting change. When Jocelyn Samuels took over, you know, if you look at what she did in just 1 year, she fined as much in 1 year as she has been fined in the last 9 years combined. She actually, last year, she levied 3 prison sentences. She permanently revoked 1 medical practitioner's license. And if you look at what was the breakout to specific ones, you know, although there was, if you take what was at the time in December, which was the 2nd largest fine ever levied, which was to Triple S, which was an insurance company in Puerto Rico. Okay, so I know how many of you have had conversations about enforcement where the belief is that it was going to be a large medical group, and most likely, you know, the expectation was that fines would never be levied outside of, let's say, continental U.S. So as you can see, they are definitely putting a broader net. Other ones that we saw last year, for example, was a pharmacy for $125,000. There was a nonprofit in Alaska fine for $150,000. We saw 2 different schools get audited. We saw, I know in our case, we saw some counties being audited and being fined, in addition to the traditional hospitals. Now, if you look at some of the details, what you'll find is, although, and for those of you who may, I'm pretty sure everyone on this call, because most of you are advanced users, the HHS wall of shame is kind of interesting. If you go and look at it, you pull what are the meaningful breaches being reported, you'll notice that it's 70–80% of the cause of the breach or the meaningful incident might have been technology related, but if you look at the fines, they are predominantly levied against what is the failure to have policies, procedures, privacy issues. And if you look at, let's say, Triple S in Puerto Rico, although there was 11 citations, I think 7 of them revolved around privacy procedures, about the fact that they were just sharing way too much information in the way they were running their business. The 2 big ones, which had to do, for example, not having proper business agreements, business BA agreements in place. And if you look at the trends of the enforcement, to Bob's statement earlier, some of it is relevant to how bad you are. Okay, and often when we get involved with what we do for a living, most people we talk to believe the auditors are out to get them. Yet if you look at them, most of the time, if you walk in and you have your ducks lined up nicely, you show that you truly have an effective compliance program, and there's a lot of ways of doing it, they tend to back off quickly, right? And we've seen situations where even though the client was clearly in a situation that they could have been fined, the auditors chose not to fine them based on the fact that they showed that they had, let's say, they had done commercially reasonable best efforts. So, without a doubt, they're not unfair. But if you take, let's say, the Alaskan nonprofit, where it was an organization that they had a security risk assessment, but they had not done privacy and administrative. You know, they had policies and procedures, but they were purchased 4 or 5 years ago. They had never updated them. They didn't accurately reflect the organization and how they ran it, and they had not been updated. And in this case, based on the age of or when that original breach had occurred, there were known changes to the regulation in that time frame. They had training, but it was deemed ineffective because it was done once a year in a classroom setting. And in this particular case, if you missed that day or you were hired the day after that, you would literally wait a year before you were trained again. So they're growing far less patient with what is people who are blatantly ignoring the laws. Now the fine schedules, although for those of you who are aware of it, there is a specific fine schedule and there is sentencing guidelines. But they are really very subjective. You know, if you have an auditor who wants to, another one of the business associate related fines that occurred about 3 weeks ago. There was 2 in pretty much 1 week. In both cases, it was either one was a laptop, another was I think a minor malware issue that caused the breach to be reported. In both cases, though, the fine levied was not for that. It was levied for what was considered negligence or gross misconduct in the way they handled their business. You know, the 1.5 it was $1,550,000. The biggest failure to have a complete risk assessment and failure to have a business associate agreement in place, in this case with their billing firm. They felt that there was 300,000 records that were exposed. And to one of the things that you heard Bob say earlier, in all of these cases, if you had just done the basics, you would most likely have satisfied that auditor from the get-go, and they would not have gone digging further. All right. So, as far as additional fines, the other one that happened 2 weeks ago, which was another hospital organization, was a $3.9 million fine. Same thing, failure to having business associate agreements in place with their providers. So, the days of enforcement is definitely getting more severe. And it was interesting. You've seen. If you take what was originally the 2 largest fines ever, which was one in New York and then the 3.5 for Triple S in December, you've now seen that they have now shifted over because you had a 3.9 and a 1.55 already this year. And I think with the stage 2 audits in place, you are going to see far higher fines. Although this is just my opinion, I think you're going to see a lot of rules being made in the market. They need to make sure that the fines are cleaned up. So, Bob, I don't know if you had anything else to add on examples of fines.
Oh, I just wanted to let everybody know that last year, now throughout since 2005, just so everybody knows, since 2005, there have been 4,817 data breaches across the United States, affecting more than almost 1 billion people. Actually, 900 million, okay? And that's since 2005. Last year, there was 58 breaches covering almost 9 million people. And this year so far, we've already had 17 covering 2.2 million people. So it happens. Breaches happen. They're going to happen. And the government knows they're going to happen. You know why they're going to happen? Because we're healthcare. It's what we do. We fax, we mail, we email, we have paper. There's so many chances to breach, right? It happens. It's going to happen. It's happened to you. It's happened to most organizations. Most organizations bury their head in the sand, but it does happen. And what you have to do, though, is you have to have a compliance plan in place that you will be able to remediate the items immediately once they happen, okay, and avoid any major releases of information. That's where the key is, right? So I just wanted to bring that up, Mark.
No, cool, perfect. Okay, let me just keep going through some of the questions, and we'll try out if they're trying to group the similar ones together, so we're keeping this dynamic. What documentation or processes are they looking for both desk audits and on-site audits?
Okay, So for when they come in to do, when they ask for the desk audit, they're going to ask for your risk analysis. They may ask for some policies, some specific policies like access controls or adding users to your systems or audit log reports. How often do you review those? They're going to ask for the physical site audit. So there's certain protocols that they're going to ask for, and when you give them that information or don't give them that information or don't give it adequately, that's when they may ask for an on-site audit. Now, they can show up anytime they want, right? So once they give you that letter that you're on the list, they can show up, or they can ask for a desk audit. If they show up, of course, they're going to be asking for the same stuff that they would have asked on a desk audit. Can I see your HIPAA policies? Can I see your risk analysis? Can I see your risk management? Can I see how you trained your staff on your policies? Can I talk to your IT? Who is in charge of IT? Who's in charge of security? Well, that's I don't know. Let me ask. Right there, you're in trouble, because everybody needs to know who do they go to for security, for privacy, and if you're a large organization, you may have a compliance officer. If you ask them who is your security officer, they should say, well, it's Jim, or that's Joni. Right, so whoever it is, that person at the front desk knows where to send them to. Have you been trained? Everybody in your organization, because that's what happened in Alaska. They walked in and said, "Where's your HIPAA manual?" And the lady goes, "Well, it's over there. It's that 3-ring binder up there. I don't know what's in it, but they tell me that's where HIPAA is." Well, right there is a big old giant check mark. So everybody needs to be trained, especially during that one-on-one audit, because they're going to do interviews. They're going to interview the compliance officers. They're going to interview staff. They're going to ask for documentation, and that's how they're going to make a determination. Are you making a good faith effort? Mark?
All right, let's keep going. I'm going to ask one which I thought was kind of interesting. And that was, I'm going to read it the way it was written, and it may not make entirely sense, but hopefully we will be able to figure this out, okay? And the question was, on the use of cordless phones for nurses that move around wards and need to answer calls to nurses' stations while they are away. And so, by the way, for those of you who don't know Bob and I on a call, I love the "Can you stump HIPAA Bob" question. So in your questions, if you have anything that is absolutely something that can stump Bob, I love to ask it. So please do throw the fun ones at me. Bob hates when I do that. But as of yet, by the way, we do a lot of webinars together. We've only had one question that Bob actually had to say, you know what, I got to check. So hopefully today we'll get the second one. So on the use of cordless phones for nurses that move around the wards and need to answer calls to the nurses' station while they are away. What do you think, Bob?
Okay, so that's an interesting question, but here's the deal. So as you would have a wireless device in your organization, a laptop, an iPad, which that connection has to be encrypted, so would that wireless phone. So if you can't, you shouldn't be using wireless phones, because have you ever been on the phone and all of a sudden somebody starts on your cell phone and something starts bleeding in? That's a wireless phone. And so they're just sending open communications. So if you're going to do that, you should have some type of protection on it. Now, if the wireless phone, if the connection to the wireless phone is encrypted, right? So somewhere, if a lot of people are using wireless phones, obviously they have some type of technology that's doing that. And that technology should have an encrypted signal that's going from the phone to wherever it's, to the base. If it's not, then you shouldn't do it, because people can tap into that. And then they can listen to everything that the nurse is saying. You could have a scanner. People can have a police scanner that can tune into that frequency. Now you're giving up all the information about patients. No, you shouldn't do that. You should figure out a different way to do it.
All right, so another one, this is kind of, this isn't a stumpy one, but I do think it's interesting, or I'm going to be curious to see you answer it. If you had a breach in 2015, do you think you're at a higher risk of getting audited?
Absolutely, they've already stated that. They've already stated that if you have breaches and they're out there and they're under investigation, you're more likely to get audited. Yeah, they've already said that.
And by the way, I'm going to add a little more to it because I've been having a lot of conversations with folks in the market that if you sit down with a calculator and say the stage 2 audits, and there's 150 organizations getting audited against the total number of covered entities and business associates in the country, the chances of being audited are pretty low, right? But often what I ask people is, how many of you have seen a device get lost in an office? All right, so the odds of that meaningful, or meaningful breach, which you had to report because it potentially affected more than 500 people, that's what's going to get you in trouble. So I don't think this is a, the chances of getting audited is not what's the chance of a random audit for me. It's more of a chance of what is the chance that you are going to have a very common thing that happens in American society where you lose a device, and now you have to report it, and you have now opened the door for what is an auditor to come and ask you the basic questions. And what we're seeing, and to reinforce, although Bob, I tease Bob because he's far more of the, you're all in trouble. I much more prefer to talk about it from a business perspective. It's not that hard. It's not that expensive. And if you do it right, you're differentiating your firm, whether you're a covered entity or a business associate. You're just telling everybody you take this stuff more seriously. And if you have the incident, which you know is going to happen, okay, the chances is what, probably 20%, 30% of a device getting stolen in an organization, at least you can show you did your best. All right, and if you do that, at least our experience in the audits and the fines we've seen levied, they are much less severe about it.
Okay, Mark.
Okay.
Wait.
Now we're going to go at it. Okay.
So before, now, if you listen to Mark's statement right now, right, some of you may be saying, okay, well then I just won't report. Oh, don't do that.
Don't do that.
Because if you get a disgruntled employee, or if that information turns up on a website, and it's noticed that it came from you and you did not report it and you knew it, that's willful neglect. That's 50,000 times every patient that's on that device, up to 1.5 million. There you go. That's going to be you. So just because it opens you up, if you have everything in place that you shouldn't have to worry, you just go ahead and report that, yep, it happens, because they know stuff happens. Again, they know it. So you report it like you're supposed to. If it's over 500, you report within 60 days. If it's under 500, you report before March 30th of the next year in one big lump sum to them. Look, if something happens, don't just bury your head in the sand like an ostrich, because they will come and yank your head out of the ground and fine you.
Okay. It's interesting, and although we are beginning to see more of it, I am actually surprised in the market that we are not seeing a lot of it. And that is, remember, folks, they can report anonymously, and depending on the monetary items involved, the whistleblowers can get a percentage. So be careful. There's already been a couple of documented situations where, an employee tried to report a problem. It was ignored by the management team, and ultimately they reported it because they felt they had an obligation to do so. So, don't. Bob makes a great point. What at least in our opinion is, telling the government that you had a problem and you are trying to solve it is a much better bet that you will either not get fined or that the fines will be minimal, versus taking the chance of denying it and getting caught. Because they are, as we've seen by some of the higher fines where you're seeing these 3.9, 3.5, the folks that covered it up are getting hit much harder than the organizations that came clean and are getting fined, $10, $20, $30,000 for their mistakes. Okay, so is there a correlation between fines and a particular practice or area of regulation?
Huh. Is there a correlation? Well,
the only one I've seen,
the risk analysis is the key, right?
Yeah. just about every resolution agreement I've seen, at one of the issues was an incomplete risk assessment, right? Where they, let's say, did security but didn't address administrative or privacy. So I think that's one area that we're seeing across. As far as type of practices, although I can't say that there's any documented evidence on this, but if you look at what we're seeing, so for example, whether it's behavioral health, dental, in this case, the orthopedic one today, if you were to look at over the last, let's say, 1 to 5 years, those happen to be the groups that have historically been the least responsive to being HIPAA compliant. Okay, and that's just, if you think about, the relations depending on what you guys do in your various different roles, those are the organizations that have historically said, I'm not going to deal with this at all. I've been in meetings with, for example, my dentist. I offered him what we do for free, and he said, nah, I don't have to worry about it. Not an issue. So I do think that, I do think breaches are causing definitely more, and that there are certain markets where they've been habitually paid far less attention to HIPAA compliance, and I do think that they are beginning to get pulled into the sunlight. So I would not. I would highly recommend, if you're in one of the, let's say, more historically less compliant arenas, I would be taking the time to be on the leading edge of getting compliant.
I was speaking at the National Postal Conference, and somebody in the audience said to me, I have a customer who, and this was their response to me when I talked about HIPAA to them, we tried HIPAA, we didn't like it, so we're not going to do it. We tried it, we didn't like it, so we're not going to do it. That was their response. And so at that point, you have to say to yourself, there's somebody who really needs some help to understand that this isn't something you get a choice on. Even if it says, even when you're looking at a lot of the regulations, sometimes it'll say you need to do it, or I can't think of the word now. It's escaped me. It's a word that says, hey,
Bob's having a senior moment.
Maybe you don't have to do this, right? You have to do it all. I mean, it doesn't matter what that says there, because if they find out that you chose not to do something because you hang your hat on a word and you could have done it, they'll fine you. They'll fine you. And I don't know why the government does some of the things they do, and I think it has to do with their, that period where people get to make comments on something, that sometimes the comments override good judgment. Like, for example, when HIPAA first came out and they didn't include business associates, that was a really bad mistake, because the government should have known that most of the breaches were occurring from the business associate, which they still are. And if you don't control your business associate and your data that you're sending to them, you could be one of those people that are getting fined because your business associate, you didn't, number one, get a current business associate agreement in place with them, and you didn't audit them to find out if they were complying with the HIPAA security rule. So that's business associate agreement and assurances. So if you get a business associate agreement in place with somebody and you just start sharing data with them and you didn't really find out if they were HIPAA compliant, well, what good was that business associate agreement, right?
Hey Bob, a couple,
yes.
Carol, a couple of our listeners chatted. The word you were searching for is addressable.
There you go. Thank you.
You're welcome. You're welcome. I'm going back on mute.
Okay. Yes, it was addressable. And so addressables, people will think, hey, addressable means I have a choice. No, you don't. You don't have a choice. If you could do it, addressable would be like the encryption thing that I was talking about. If I'm going to address encryption here, oh, you know what? I can't do it because everything stops. Well, in that case, then you don't do it. So what you do is something different. You do more physical security. But if you look at something and say addressable, oh, cool, I choose not to do that. You better have a very good reason why you didn't do it, because they're going to say you could have done this. Why didn't you? That's a check mark. Okay.
All right. Well, okay. So now I'm going to we have a bunch of questions that have come in under business associate. So let's
Sure.
take a minute or two and kind of, I'm going to, some of these, because I do think we're finding more and more in the market because, you know, omnibus is becoming far more enforced and close to, well, if you look at just the fines, you are in 4 months, we're north of 10 million in fines already for BA-related issues.
Mark,
Oops.
before you answer that question, I
Yep.
just want to say one of the reasons why this is coming so prevalent now is that the first thing that was on the list that the government sent out to people who are being audited is, the first thing we're going to ask for is your business associate list and your business associate agreements. It's the first thing on the list. So that tells you right up front there's something going on with how they're going to start attacking business associates in these audits. It's just my thought process.
No, I agree with you. I think they're, and it is scary. Before we do the BA thing, I'm gonna share one example. I was meeting with an association, and the president of their, or the chairman of their board, after I'd been working with their executive director, got on a call, and I will not tell you the association because that would be embarrassing for them. He literally said after about 5 minutes of conversation that we did not need to continue the conversation because as far as he was concerned, and he was a very knowledgeable person in his mind, that all of his members used laptops and that their EHRs were provided by the hospitals they served, therefore they did not have to worry about HIPAA compliance. Okay, and I will say it did bring a big smile to my face when about 6 months later, in his area of specialty, there was a $750,000 fine for specifically for a laptop being stolen. Okay, and the issue was why they were fined so heavily was the government said, wait a second. By nature of what you do for a living, people are wandering around with a laptop, yet you didn't have policies, procedures, and security protocols for those laptops not to be left in cars and that the data wasn't properly encrypted. For that, you get fined heavy. In this case, it was $750,000. Okay, so let's talk about some BA-related questions. So how often should the business associate agreements be updated to avoid fines?
Awesome. Okay, so your business associate agreement should be updated when the rules change, but otherwise they need to be reviewed every year. When I say reviewed, what you do is you look at your business associate agreement that you have in place. You look at the business associate that you're sharing data with. Has your relationship or any reason to change that business associate agreement? Is there any reason to do that? If it's not, you must document that you reviewed the business associate agreement, you reviewed the relationship, there are no changes, and you'll review it again next year. And so the current business associate stays in place. Now, if that relationship changes, they're sharing different information, they're sharing more information, their company name changes, the rules change where you have to add something to the business associate agreement, then you have to get a new one signed. Same thing with confidentiality agreements. Oh, what are those? Well, look, some people don't even know what business associates are. Okay, they say business associate, it's like everybody gets a business associate agreement. Not true, right? So the key here to a business associate is this. A business associate is somebody that you hire to do something for you. That requires you to either share directly with them protected health information or give them access to it. That is people like your EHR, your collections, your clearinghouse, your storage, whether it's electronic or paper, your malpractice insurance, your lawyers and accountants if they see protected health information. So if you can think of many more. If you hire them to do something for you and you're sharing it with them or you're giving them access to it, that's a business associate. Your cleaning guy, your copy guy, your fax guy, building maintenance, cleaning services, they're not business associates. They should be getting confidentiality statements that say anything you see, hear, or touch while you're on site, you will keep confidential. Big difference.
So the next question that came in, which I think is an interesting one, and we get this a lot, is a covered entity responsible for checking if a BA appears to be HIPAA compliant?
I just talked about this. So remember, it's assurances, right? So you're putting your money, your compliance money, okay, which you may have to give to the government, in somebody else's hands when you hire a business associate. So when you hire a business associate, your business associate agreement should say something like, you will provide to me documentation on your HIPAA compliance. Okay? Flat out, straight sentence, you're going to do this. And then you should audit them. You should have some type of security audit asking, do you have policies and procedures on security? Do you do a risk analysis? Do you have risk management? Do you train your staff? But, whatever the requirements are of security. And then what you do, and then you track that information in a profile for them. So if the government comes, so look, so now your business associate breaches, okay? And it's your data they breach. And they knock on your door. You want that documentation that says, I got a business associate agreement, and I've got that they were compliant with HIPAA, right? Whether they are or not, that's not your issue at that point. If the issue is this is what they provide to me, because the rule says that you don't have to go and do an audit there, right? That'll be the government's decision. So when you show them, I've got the business associate agreement that says they're supposed to be HIPAA compliant, and I've got the audit that they sent to me, right? It's all on the business associate now. It's not on you anymore. It's not your issue, okay? But if you can't, then you're both going to be in the bucket. You're going to be in the bucket because you don't have enough. You don't have the right business associate agreement. You didn't find out if they were compliant, and you just shared data with them. So they're going to throw you in there with them. You want any time. Think about it this way, okay? I want you to think about compliance in a different way here, okay? It's kind of like being a karate fighter, okay? Every time they throw something at you, you want to be able to block. You want to block this. Hey, would you? I block. So they get to the point where they don't want to fight with you anymore because they can't hit you. If you have everything that I was talking about today, and you keep showing them, do you have this? Yes, I do. Do you have this? Yes, I do. Do you have this? Oh, Jesus, forget it. I don't want to deal with you anymore because I can't do anything to you because you have everything in place. All these questions you guys are asking are things that you should have had in place 10 years ago. This rule's been in place now 11 years. So if you gave yourself a year to do it, and if you've been in business for 11 years, you should have had this in place a long time ago. Because when they knock on the door, they're going to look for they're looking for a full-blown compliance plan. Okay? Not something you started 3 weeks ago. So it's time that we really, really need to start buttoning down on this. Just my personal opinion.
Yep. And to add to that, if you think of a business associate agreement, and what really needs to be in there is just what I would call good fences make good neighbors, right? It defines who's responsible for what. I see a lot of business associates, and this is one of the questions that came up is, if the covered entity didn't ask me to sign a business associate agreement, I don't need to be HIPAA compliant. It's not true. You need to be HIPAA compliant. If you're a business associate in the market, you need to be HIPAA compliant because you are a business associate in the market, regardless of whether or not your clients ask for a BA agreement. What often when I'm talking to folks like this is, why wouldn't you want a BA agreement in place? Some people think it increases their liability. I personally think it limits your liability, right? It's clearly defining that we're going to function under HIPAA, and that if I'm responsible for what I do and you're responsible for what you do. Without it, you're leaving yourself exposed to what is an auditor coming in and saying, I'm going to find both of you. You guys didn't define it well, now I'm going to. Okay, so this is kind of an interesting one, Bob. I'm going to give you kind of I've not heard one asked quite this way before, okay? So, let's go. Should two different business associates that work for one covered entity and trade PHI with one another have business agreements with each other, or would a memorandum of agreement suffice?
One more time.
Okay, so there's two different business associates providing a service to one covered entity. The business associates are exchanging PHI with each other on behalf of that covered entity. Do they have to have BA agreements with each other?
Okay, so the answer is yes. So think of business associates and a covered entity as a chain, right? So you've got the covered entity hired a business associate. So one of them had to get hired first. I don't know because I can't talk to the person. So one of them probably got hired first, and then that person is sharing with somebody else. So that's a chain, okay? The covered entity only has to have a business associate agreement with the first person they're sharing PHI with, okay? Now, if that person is sharing data with both of them, right, then that covered entity has to have a business associate agreement with both. If the business associates find it necessary to change information with both of them, they have to have a business associate agreement also. And that's a BA to a BA.
So on that note, okay, and next question, which was somewhat related, is if a BA is a hybrid entity, okay, and I think we've seen some folks that are, depending on who they're talking to, they could be a covered entity, they could be a business associate, it depends, right, or they're both often in some cases. Is there a preferred method or documentation process for declaring a hybrid status?
Oh.
That's a good, maybe, that might be a stump one. I don't know.
No, it's not a stump one. It's not a stump one. And in that instance where you're going to make a determination on what type of organization you are, you need a lawyer. You have to have a lawyer make that decision, and you have to have his paper stating of what you are. Don't make that decision on your own. So you need a lawyer to draw up that you are a hybrid under the law because of A, B, C, D, E, right? It's not for me to make that decision, and you want to be able to have that document able to show it to the government because their audit of you will be different. So you're going to want to make sure that you get a healthcare lawyer, right, to draw up and make the determination of exactly what you are. Yeah, that was an easy one, Mark.
Oh, darn. Someone give me a Stump Bob one. All right, so you need one better than that? Okay. This one is not a particularly stumpy one, but I think it's an interesting question, and that is, how likely is that a business associate will be audited as opposed to a covered entity? And I think it's just, if you just look at the market, it's probably two-thirds of the market are covered entities and one-third is business associates, but you're equal in the eyes of the law, all right? So your chances are not more or less. What I do think that there is, and this is, I'm going to kind of put the disclaimer up here, this is my opinion, okay? And that what I believe is happening is it is a logical thing for the auditors to say, an individual covered entity can really only screw up their own stuff, right? But if a business associate is failing and is not HIPAA compliant, their impact is much larger in that they could have 20 clients, they could have 200, they could have 2,000 clients. So I do think you are going to see, and if you look at the official dispersion or breakout in the stage 2 audit, it's two-thirds covered entity, one-third business associates. But my gut is the business associates, because their lack of compliance can have a very multiplicative effect on the market in a negative way. I think you should be planning for there is a higher likelihood that you will be audited, and if audited, that they're going to go deeper into what you do, because you could be screwing up hundreds of organizations, tens of thousands, if not millions of records. I mean, look at Anthem Blue Cross, 79 million people affected in one breach. Right, so I think the question is a good one. I don't think there's a definitive answer from the government yet, but I would be prepared for you guys being in the sight of audits a little bit much more prominently this year. Bob, I don't know if you have anything to add to them.
Oh, I agree. I just like I said before, the first thing they're asking for is business associates, right? And I think that at the beginning you're going to see a lot of covered entities because that's what their target list is, but as the year goes on, you're going to see more and more business associate agreements showing up in audits.
And Carol here. Real quick.
Hi, Carol.
Hello. Real quick interject. Back to the question about the two BAs sharing and the sort of the daisy chain, Bob, that you talked about. One of the listeners chatted in. Would you then use a subcontractor BAA agreement?
As long as it's a business associate agreement, right? As long as that it has all the necessary language of a business associate agreement, whatever you call it, doesn't really matter.
I see. That's just right. It's the semantics. Okay.
The semantics of it, right? So you can call it whatever you want as long as it has the proper, legal business associate agreement language.
Okay. You guys got about 5 more minutes, so just FYI.
Okay.
Wow, time flew. Hopefully we're keeping you all entertained. On the BA agreement, just one more additional thing is one of the ways that I found help people when we're talking to them is, and this may make it easier to define who should have a BA agreement with who. But look at it in very simple terms. If they are doing something on your behalf where they're going to be touching PHI or the potential to touch PHI, put a BA agreement in place. It just protects you. Protects all parties involved, whether they're subbing off a sub to a sub, and I'm not being a wise guy, I'm using an example. I've seen a lot of the IT or the telemedicine firms that, their presumption is that because the hosting service was compliant, that made them compliant. Not correct. That their remote programmers didn't need to be compliant because they were independent contractors. Not correct. If they are doing work where they can touch PHI, you really need to make sure that the BA agreement, I think, is a great way to define the liability and protect you from getting ensnarled or snagged in somebody else's mistake. Because when it's all said and done, folks, if you look at the majority of fines and audits, it's human error. Right? It's someone forgot to do something, someone did something, and just they made a mistake, whether it was done with malice or just negligence or sheer stupidity. When you look at, many of the audits from last year and the fines that were levied, as an outsider looking in, you're like, why? It would have been such a simple thing to avoid if somebody, compliance officer or somebody on the executive team, or maybe just even the person on the front line, had taken the time to just follow some basic tenets of how to be compliant. So hopefully the market gets that. Bob, anything else to add? As we're down to our last 3 minutes, I don't know if you have a closing statement or.
I have a final thought for everyone. The seven OIG,
the fundamental elements of an effective compliance program.
Right, there you go.
Is that the word you're looking for?
Yeah. Those are the ones that you really need to concentrate on and have in place in your practice. If you don't have a complete compliance plan now, you should start working for one. You should start making sure that you have audited yourself against the regulations, that you have policies and procedures covering all regulations, that you train your staff on those policies and HIPAA 101 and fraud, waste, and abuse if you bill Medicare, and on incident management, because you're going to want to have an incident management program, and you're going to want to do that risk analysis. You want to do the risk analysis, the device audit, and the physical site audit. If you have that all in place, that gives you a complete compliance plan. That will allow you to every day, week, month, year, be able to have all the necessary documentation and have everything in place that you will be able to survive an audit. I call it surviving an audit. If you don't, if you're missing some of that, your fine will be based on whatever you're missing. So be careful and move towards a compliance plan. My final thought.
Your final thought. First and foremost, we did not get to everybody's questions, and we got to a lot, but we had a lot left over. So feel free to email Bob and Mark. They will take your question via email. bob@compliancygroup.com, Mark with a C at compliancygroup.com. Please check out their website, compliancygroup.com. .com. There you go. Bob, Mark, this was fun, and I look forward to seeing you guys back again on HIPAA-Chat. And to our audience, thanks so much for joining us today.
All right, Carol, thank you very much for having us. It was a lot of fun. And to the attendees, we were kind of straight. We will try to be more fun next time. And please do bring a Stump the Bob question, because that makes me so happy when he has to stop and say, shoot, I don't know an answer to that one.
Addressable.
11 years we've been playing.
Addressable.
11 years.
Addressable.
Yeah, addressable.
Take care, guys. Bye.
All right. Thanks, Carol. Bye-bye.